My former spouse says she wants to move away with my kids. What am I going to do about it? Well, that's called relocation with your children. And there's a special and specific procedure you must follow in the state of Florida to either obtain that goal or to object against that goal. In Florida, if you are going to move more than 50 miles from the location where you were located at the time that you were divorced, and you are the primary timeshare, or as we used to call primary residential parent, then you either have to obtain written permission from your spouse or the court's permission to do the move. If you move and fail to obtain those, then the court can order the child to be returned to the original location, which would really mean, if you were going to stay where you moved, that your former spouse would obtain custody or primary timeshare of your child. So this is an important process. How do you go about doing it? If you're going to request a geographical relocation with your child, you must file a petition with the court in which you ask for the relocation. That petition must contain many particular pieces of information. Some of those are: 1, the date in which you propose to relocate; 2, the address and description of the place where you're going to relocate. Obviously, there would be a big difference between moving down the road 20 miles or, say, moving into outer Mongolia. 3, what are your proposed visitation and transportation for the other parent in the event that the court grants your relocation? It is very important to be, and then finally, what are your reasons for the relocation? Clearly, if you're just moving down the road because you like the structure of the buildings in that development, or you're going to be moving away because of many different reasons, the individual with the greater detail is going to have a greater chance of being successful than one who just has one frivolous reason for doing so. What does the other spouse do? Well, the other spouse has 20 days in which to respond and or object to your petition. If that spouse objects in writing or provides a written response and objection, then you can't leave without the court's permission. You only get divorced usually once in your life, so it's important to consult with or be represented by an experienced, board-certified family and marital lawyer. Thank you.